Alright. So, I'm going to be talking about some of the workability issues with the plan the opponent gave us, and also a feasibility argument. So, the plan the opponent gave us was that Congress needs to pass a law for presidents to consult Congress before passing any executive orders. You know, that plan to me is unnecessary, and because that already exists. The executive orders can be overturned by federal courts, and also by a 2/3 majority vote by Congress, which you've already heard today. But not only can it be overturned by Congress, but it can be overturned by judges in a federal court. And also, executive orders have a very specific criteria they follow when they're ordered. And to quote, if an executive order has a specific statutory foundation, it is given the effect of a congressional statute. If an executive order conflicts with an existing statute, the executive order must fall. So these orders aren't made without any with just complete word of the law and power in your hand. That you have to follow certain rules. And then to address the feasibility of the plan of the opponent, it also goes back to what Jacob said about amending, instituting an amendment. It's an extremely long process to do, and it usually never happens. To quote, a proposed amendment has to become part of the Constitution as soon as it's ratified by 3/4 of the state, which is 38 members of the state. Also, it needs to be supported by 2/3 majority vote in both House of Representatives and the Senate. So that's two things that aren't very likely to happen. So it's not feasible to say, nor is it feasible to say that that these reckless actions by the president are damaging enough to the United States to where their power needs to be restricted, because the executive branch derived from the executive power itself. So what that means, to quote the Notre Dame Law Review, the executive power shall be vested in the President of the United States of America. With these words, the framers of the Constitution created the office of the President, who is the head of the executive branch of the government. The administrator directs whom heads the governmental departments and agencies responsible. So pretty much what that means is to take away the executive order power from the president would be diminish the job. It would be to diminish the job in an overall sense, making the job somewhat pointless. And also, my opponent brought up the War Powers Act, and it's basically saying Congress has passed a law restricting executive power, which kind of helps to our point, saying that these laws are already in place themselves. So I don't know why would they need to be implemented in their plan is an issue. And when the opponent talked about the point that a lot of the times Congress is in the dark on what the president is doing, and they don't know, and the whole point of the separations of powers and checks and balances is so that Congress doesn't have the power of what the executive branch is doing, the split of their force. So even though that's kind of maybe a disadvantage, it'd probably be the Congress' fault that they don't know, or the system they're building in general. So maybe changing the executive order power would not be the right thing to do. Maybe another thing, maybe changing another part of the system, because that wouldn't solve the problem.